I believe this is a contest of a sip. Is that right?
That's my understanding, Judge.
All right. Ms. Bryden, you and your co-plaintiff were awarded, let's see if it was a default or an actual PDC.
Pause right there. A default judgment means one side didn't even show up or respond in time, and the court ruled against them automatically. So now the real question isn't who's right, it's whether the losing side even deserves a second shot. And that all hinges on one thing: can they afford to appeal?
Looks like a default judgment was entered on January 6th, and then we received a notice of appeal from the defendant along with this SIP. All right, Ms. Dryden, why do you believe that Ms. Moore is capable of posting the bond for appeal?
Well, Your Honor, she has an attorney that she's hired or that's in present. That's one indication that there must be some funds available.
Do you know if she's actually paying for the attorney?
No, I don't. So,
what other reasons would you have for contesting this SIP?
Also, when I paid her through an LLC, and she only provided information, her personal banking information, but she didn't disclose any LLC information, and that's how she was paid. I didn't pay her a personal Chase account or any of that. I paid attorney Barbara Moore LLC group, something like that is what I paid.
In Miss Moore's affidavit, did she indicate that she has any income?
Just her Social Security.
Do you believe Miss Moore is retaining it has?
Wait a minute, did you catch that? She claims limited income, but at the same time, she's traveling for legal work across multiple counties. So what's really going on here? Is this a case of hidden income, or just loose storytelling under pressure?
Income that she's not disclosing?
Well, I know that on a couple of our court cases that she has postponed and asked for continuance. She continued to say that she was a traveling attorney and that she had, I believe, cases that she was working on and had to go to court for those cases. Therefore, she wasn't able to meet your court dates. So I don't see any of that income either noted. And I don't think that she's traveling to these different counties for free. I believe that the same way she charged me for my for being an attorney for our case, that she's charging others. And again, I don't see any LLC information.
All right, anything else, Ms. Dryden?
No, ma'am.
I'm looking back at the continuances. Marina, what information would you offer?
We would offer the affidavit. We also had the lease agreement that we've submitted in 2 months worth of checking accounts that show her only source of income at current is the Social Security, Judge. And then any tested. I'm sorry?
How about Medicare? Was she getting any of that?
Judge, I don't believe so. I'm flipping through it now.
I just look at, on her SIP application, she wrote Medicaid and SSI, and then her total take home is $2,097.
Yes, Judge, that's my understanding as well.
And Mr. Marino, are you charging Ms. Moore for your services?
No, Judge. I see where it says Medicaid. No, Judge, I've never charged her. And my office staff, they provide the backroom stuff for her, but we don't charge her for that. She's a friend of the office, Judge.
Marina, at this point, does your client have any active cases? Is she currently representing anyone in court?
She is still traveling, but not getting new cases, Judge. She is winding down the practice, as currently the practice costs her money. So she doesn't bring in any positive income, but I don't believe she's receiving any payments at this time.
How many current cases does she have?
Judge,
This is where the judge flips the script. If you're well enough to work cases, even for free, the court may assume you're capable of earning money. And legally, capable matters more than willing. That's a huge distinction, and it could cost her the appeal.
I'm unaware. I wanted to say it was 10, but that's a long time ago since I've talked to her about it.
Ms. Moore, How many active cases are you traveling about for?
Right now, Your Honor, I have, let me count, just one. I have what, four cases.
You have
And
four active
Judge,
cases?
I would ask her if she's getting paid on those cases, if those are pro bono cases.
No, I'm not being paid.
Are you taking them pro bono or do you expect to be paid?
Pro bono, Your Honor. I do mostly pro bono.
Is that because you can't get paid?
It's because I'm 65, 68 now, and I still like helping people. So I do that, Judge. I get a wonderful result of helping.
I appreciate that. All attorneys need to do pro bono. I applaud that. Thank you. But we're here because they're saying that you can't afford it. My question would be like, can't you go and get hired as an attorney? You are a licensed counselor. If you're doing pro bono work, that tells me you are still capable. So why are you not being hired?
Most of the people I have, Your Honor, they don't have the ability to pay. And I do take those cases more than anything else.
I appreciate that, but you cannot afford your bills and are here to say that you can't afford it when I don't see that you are incapable of earning the money. Right? The standard the court is given is, can they do it or are they not doing it? Nothing about what I'm hearing says you couldn't make money. You're just choosing to represent people who cannot afford it, which is wonderful and noble, but does not mean you can't afford your bond.
No, Your Honor, I can't currently do that. I've been sick. I don't work.
I find a discrepancy in that, Mr. Barina. You see my point? If she's too sick to get paid, then she's too sick to do it for free.
Right. The cases that she's working are closely monitored by me and other lawyers because we're transitioning to the next phase. We closely monitor. This one was an old case, Judge. We were unaware of it until it made its way into the state bar system. But what I'm trying to say is, Judge, is without being closely monitored, she should not take a new case. And the other lawyer is David Fernandez Jr., who assists also in monitoring the cases so we can wind it down to 0 cases.
Ms. Moore, is it your testimony before the court today that the only source of income you receive is the $2,000 from your Medicaid and Social Security?
Yes, Your Honor.
How about the LLC that Ms. Dryden said she made payments to? Are you the current owner or a member of an LLC?
Let's see.
I'm sorry, Ms. Moore, I couldn't hear you. Is that a yes or a no?
It's no, Your Honor.
There's no LLC?
There was an LLC, but
When did that get dissolved?
that would have been, let's see, I haven't had LLC cases probably 3 or 4 years now.
Was it formally dissolved or have you just not used it anymore?
I don't use it anymore, Your Honor. I was working under Be More LLC, and I don't have that anymore.
When's the last time taxes were filed for that LLC?
Taxes in the LLC, let's see, it's been quite some time. I want to say probably, I stopped doing those, probably about somewhere between, let's see, when I get sick, probably somewhere between 3 to 5 years or more.
Ms. Dryden, when did you last make a payment to Ms. Moore's LLC?
Your Honor, I paid her in full what she charged. October the 1st. October the 1st, 2023 is when the transaction went through my account.
Ms. Moore, would that be correct? Did your LLC process payments from the plaintiff in 2023?
Gosh, I don't believe that's correct, Your Honor. But I can't say when it was exactly because I had 1 or 2 different things that were started off with. It was another person and they got off. So I can honestly say that it would have been somewhere around that time, but I was not paid in full at one time.
I'm going to share my screen. The
Excuse me.
exhibit you provided is a copy of a request you had to pay the Be More Law Group.
Yes, ma'am.
All right, and is this the Law Group LLC?
Yes, ma'am.
When did you receive this?
And there it is, the receipt that changes everything. Moments ago, the LLC supposedly didn't exist anymore, but now we have documented payments flowing through it in 2023. That contradiction? It's exactly the kind of detail judges zero in on when credibility is on the line.
September the 20, the day before it went, I think the 30th of September,
What year?
2023.
All right, Ms. Moore, do you recognize this receipt or this invoice?
More on group. Let me see. Yes, I do, Your Honor.
All right, is this a bill that your company sent to the plaintiff?
Yes, Your Honor.
All right, so at least as 2023, the LLC was taking payments in.
Yes, Your Honor.
All right, and then Ms. Dryden, this is the other document you sent us. Is this a copy of the receipt when you paid?
Yes, ma'am.
Is this also for the Be More Law Group LLC, October 2023?
Yes, ma'am.
All right, Ms. Moore, is this a correct receipt for your company receiving $8,000 from the plaintiff?
I don't believe it was 8,000, Your Honor. I think she paid in maybe in pieces. I don't recall that it's $8,000.
All right, but to the LLC? Ms. Dryden, you've also provided me with information related to a bond. Oh, I see. You're saying she put a bond down. Ms. Moore, were you responsible to post an out-of-county bond in 2024 in New Braunfels, Texas?
And bonds will purchase a bond.
Yeah, I have a surety bond of $12,000.
No,
State
ma'am.
of Texas versus Taylor Merritt Marie Armstrong Threadgill Dryden. Oh, that's you, Miss Dryden.
That's her. Yes, Your Honor. I never.
That's not you, Miss Moore. Fine.
Your Honor.
Mm-hmm.
That was to show, that was evidence to show that she never.
Oh, for your daughter's case. That was the evidence for the underlying case. Okay.
Yes.
All right. And then this is getting into the stuff that came from your original case.
I'm sorry.
No, that's fine. I'm just looking back through what was submitted today and then what we received. Okay, and then Mr. Rita, you gave us a copy of the lease that Ms. Moore has.
Yes, ma'am. To show the amount.
Is your client behind in her rent?
No, Judge.
Ms. Dryden, is there anything further you'd like to present the court?
Not at this time, Your Honor.
Mr. Barina, anything further you'd like to present for Ms. Moore?
Judge, I think you've gotten it all, the affidavit and the checks and the lease, Judge. Thank you.
All right. Let me take it under advisement. I do want to check again with some standards that the court has given, not our court, but OCA has some guidelines about kind of how we weigh out the numbers for these things. I have gotten a good amount of information. Ms. Dryden, thank you very much for the information you've given. Ms. Moore, Mr. Barina, thank you for providing the information related to your lease, as well as answering the questions I had about some of the income status. I'll get y'all an answer within about 2 days, okay? I won't leave you waiting here. I understand this is a holdup, so that if she needs to post the bond, you have to have an amount of time, and if it's not, we can move it immediately along to county at law.
Thank you, Judge.
All right, thank you both very much. All parties are excused.
Thank you.
Thank you.
Thank you. All right, next is going to be 25-1576. This is Fazal Ali versus Aura Hookah Lounge and Aura Island Lounge. On behalf of our plaintiff, Ali.
Right here, Your Honor.
Good morning. And do I have someone here on behalf of Aura Hookah Lounge?
Right here, Honor.
Good morning. Tell me your name, sir.
Hey, my name is Sharif Bakri. I'm the owner of Aura Island Hookah Lounge.
Okay, and how about Aura Island Lounge?
I don't have anything to. I'm not part of Aura Island Aura Hookah Lounge.
So you're here for Aura Hookah Lounge.
For Aura Island Hookah Lounge.
Here's why I have to ask it this way, because the plaintiff filed it as though it's two completely different companies. So is it two companies or is it one?
Two different companies, two
Okay.
different LLCs.
One of them is
Your
Aura
Honor.
Hookah and one of them is Aura Island. Is that correct?
That's true.
All right. Are you, Mr. Bakri, here for Aura Hookah?
Aura Island.
You're here for Aura Island.
Aura
Your
Island.
Honor, I'd like to make the case that they are the same entities, but I think
Mr.
that's a
Ali,
matter
we'll
of
get to
the-
that, but
Yes.
I've got to check the parties in, okay?
Yes.
Mr. Bakri,
Understood.
you're saying that you're here for Aura Island. Are
Aura.
you at all here on behalf of Aura Hookah?
Nope.
No one is appearing on behalf of Hookah.
No.
Okay. All right.
I'm just here for Aura Island Hookah Lounge.
That's fine. This is also, what, are we also doing a SIP request on this one, or a SIP contest? All right. Looks like, Mr. Ali, you received a default judgment in February, and then we received an appeal from the defendant, and they appealed it with an affidavit of inability. All right. Mr. Ali, why do you believe that Mr. Bakri is capable of posting the bond?
Thank you, Your Honor. I'd like to make 2 points about why the statement of inability should be rejected.
And Mr. Ali, before we begin, let me swear in both you and Mr. Bakri.
Yes,
So
of
both
course.
please raise your right hands. Do you understand that by appearing in court, offering me testimony, you swear to tell the truth, the whole truth, and nothing but the truth under a penalty of perjury? Do you so swear?
Yes.
Okay. Fantastic. Go ahead, Mr. Ali.
So my first point is that the statement of inability was filed personally by the owner. However, the judgment is against the two LLC, the Aura Hookah Lounge LLC and Aura Island Hookah Lounge LLC. The statement of inability listed personal finances, personal assets. However, none of the business assets were listed. My second point is that the business itself has been operating and generating revenue as recently as yesterday. I've provided some exhibits to showcase this, exhibits A through F. Exhibits A through F show events that are being held, times of operating hours, as well as an event that was conducted along with other numerous events where as many as 66 people showed up. Their tax status is also active for this LLC. So the business is open, it's generating revenue, and the statement of inability does not reflect the LLC's finances at all. That's who the judgment was against. So I'd like to ask the court to reject the statement of inability and request an appeal to be posted, bond to be posted, I mean.
All right. Pull up the actual, so we can look at it. So there's Aura Island, my name, personal information. All right, Mr. Bakri, how would you respond? I am looking at the affidavit of inability, and it is correct. It does not include any information related to the business assets. It appears to be your personal statement. What could you tell me about Aura Island's finances?
So Aura Island was formed on November 4th, 2024. Doesn't have anything to deal with Aura Hookah Lounge. It was under a new owner and new lease. And respectfully, I don't know either of the parties, or I'm not even part of the agreement. So I don't know anything about the agreement, and I don't know either of the parties.
All right. That may be true, but in terms of appealing without having to pay money, you got to prove that your company can't afford it. So did your company file taxes last year? It was formed in 2024.
This is a brutal reality check for business owners. LLCs aren't treated like individuals in court when it comes to claiming financial hardship. You can't just say, I'm broke. You have to prove the business itself is broke. So ask yourself, if your company were in this position, could you prove it?
No. I was in a process of remodeling. The first day of opening was March 1st,
Of what year?
2025.
All right. Do you file quarterly taxes?
Sorry?
Does your company file quarterly taxes?
What is that?
I'm going to say the answer is no then. You would know if you did. Okay. Does the business have any current business accounts?
Yes, it does.
All right. And are those accounts in arrears?
Yes,
Do you have any proof of that?
I do.
Can you submit that to the court
Yes, I can.
today?
Yeah, I can do that, yeah.
All right. I'll take it under advisement, but I'll just say right now that typically an LLC is not going to qualify for a SIP, so you're going to have to post the bond unless you can show me proof very specifically that there's absolutely no money in the account. But typically LLCs do not qualify for SIPs. It's meant for individuals.
Okay.
But you can send me something. I'll take a look at it. But I'll just say that on its face, probably not going to qualify. Certainly,
So-
you can provide me with some information about it, and I will review it.
Okay, just so you just need to prove that the business. I really didn't get it, to be honest, Your Honor.
Mr. Bakri, we're here because you filed an appeal. You said that you can't afford to post the $10,000 bond, which is required as the defendant in that case. In
True.
order for me to approve that you say you can't afford it, or that your company you own can't afford it, you have to give me proof that the company is insolvent. Because typically LLCs do not qualify for an affidavit of inability. As a company, the court says you're supposed to take care of your stuff. Not you personally, your company, right? And that's why Mr. Ali was was accurate and pointed out that your affidavit says you individually don't have the money, which may be true. That is
Yeah.
not the same as your company being unable to do it.
Sure.
All right, so I'll give you till the end of the day to submit some information. I'll review it. I'll take this under advisement. I'll get you both an answer within about 3 days. Mr. Ali, yes.
Your Honor, if I may, the business also has assets. They have inventory. They have regular generating revenue. So I just wanted you to take that into account as well.
But Mr. Ali, I will highlight that just because a business has inventory doesn't mean they have paid for it. Quite likely, or possibly, it is being fronted to them and they have credit on it. So they may be selling something to immediately pay it off, which is honestly how all car dealerships work. All right. So that may be true that he is operating, but whether or not he is solvent and can afford the bond, or his company is solvent and can afford the bond, is a question of fact. So Mr. Bakri, you can submit information today and I will review it and take a look at it. I'll just again highlight though that there's a different standard for individuals versus businesses.
Sure.
All right. Send me that stuff, Mr. Bakri, and I'll take a look and I'll get y'all an answer within, like I said, within about 3 days.
And another thing, it's as I said, Aura Island doesn't have anything to deal with the part of their agreement. So,
Mr. Bakri, that's the reason you're appealing, is to take that issue up. But no one came on behalf of either company to the lawsuit, and as a result, the plaintiff won by default. I cannot set aside that judgment now. That's what the appeal will do if indeed you have been sued wrongfully, your company. But today it's about whether or not you've got to put down money, or your company has to put down money to be able to go to court and say that they sued the wrong company.
okay. Makes
All right,
sense.
that's what happened. Y'all were
And just like that, everything comes down to evidence, submitted by the end of the day. No more talking, no more explaining. It's now a paper battle, financial records versus claims. And in court, documents don't just support your story, they are your story.
notified, I proved it, no one came, default entered. In order for you to have a new court hear that case, a bond has to be put in. And I'll just say that, Mr. Bakri, the only appeal here is for Island. No one's appeared on Aura Hookah. As far as that company is concerned, no one is continuing to show up for them. So they keep having what the court would find to be disrespect because no one is appearing on behalf of that LLC. I don't know if you know who they are, but if you do, let them know that if you feel like it.
It's Cameron.
You're only here today for Aura Island. That's why I was very specific in asking you.
Yeah, I'm here for Aura Island.
I got it. No one's here for Aura Hookah.
No.
Okay.
And it's not even the same entity as well.
I agree. That's why there's two different names, and that's why I was very Mr. Backer. That's why I asked you, are you here for one or both? So no one checked in. We're going to mark it down that absolutely no one came today for Aura Hookah because no one did come. But someone came for Aura Island, and that is you. And Mr. Ali came for himself. And so our hearing is about whether the SIP can work for Aura Island.
Okay.
All right.
So basically, we're talking today just about the appeal.
That's it. Wholly about whether or not y'all can afford the company Aura Island can afford to post an appeal bond. That's the only question that we have today before the court.
And is there like a specific information like I can submit?
Mr. Becker, I can't give you that advice. I'd say that the plaintiff is saying that they believe as an LLC that the company has sufficient assets to be able to post a bond. And he's provided me with reasons why he believes that there's an ongoing business, that there's advertising, that they have inventory for sale, that they're hosting events, that those events are bringing in money, that therefore it looks like a going business that could be able to afford a bond. And I think he's meeting his burden pretty well. In order for your company to prove that it cannot, some evidence is going to need provided to show me that no, we are insolvent. We do not have that funds. That even though we're advertising and we're hosting these events and we've got inventory in the store, we do not have funds sufficient to be able to post the bond. That's the question of fact. So Mr. Ali is meeting his burden to show me that it looks like the company couldn't do it. It would now give you an opportunity to counter that.
Yes, Your Honor. Yeah.
All right. Now get it to me by end of the day and I'll take it under advisement and then I'll get y'all in order.
Thank you, Your Honor.
Thank you very much. All parties are excused.
And just like that, everything comes down to evidence submitted by the end of the day. No more explanations, no more back and forth in the courtroom. At this point, it becomes a silent battle fought on paper, where financial records carry more weight than words ever could. The judge isn't looking for arguments anymore but for proof, something concrete that either confirms or dismantles the claims being made. In situations like this, documents do not just support your story, they become your story, shaping the outcome in ways no last-minute defense ever can.